Hi, my name is Brian Lafredo, and I am the practice group leader for the Construction Law Group. Last year we did a roadshow, and we highlighted one section of our group, which we commonly refer to as the Construction Claims Group. Those lawyers represent owners, general contractors, subcontractors, suppliers, and engage in general types of construction disputes involving non-payment and other related cases. Now, Offutt Kirman has another subset of construction lawyers, and this subset has grown significantly over the past year. We commonly refer to them as the A&E lawyers. A&E stands for architects and engineers. These are design professionals, and our A&E group represents these design professionals, as well as interior designers, lighting designers, and commercial residential owners and contractors are also part of their scope of representation. Housed in New York, Philadelphia, Plymouth Meeting, and Harrisburg, Offutt Kirman's A&E group provides a wide range of services to design professionals, and they do this not only in Offutt Kirman's footprint, but in other areas of the country as well, and also in other countries. They also deliver frequent seminars both to clients and others in the industry. Rest assured, Offutt Kirman, the A&E attorneys are ready to assist when you need them. So who are they? Well, they're Bob Herman, Paul Helgers, Lindsey Johnson, Wojtek Jakowski, Tony Potter, Franklin Miller, and Kevin Watson. And with that, I will turn the presentation over to the Offutt Kirman A&E Group.
I think that it's always good to find out if they're involved, what kind of projects they might be involved in at that time, and whether what kind of issues they might have encountered in the course of those projects, and then that might lead to an opportunity to introduce that person to someone in the construction group who could give some further advice on those issues. I think that's what I've found over the years, is just to be talking to, when you meet architects, try and find out what kind of projects they're doing, what the nature of their projects, and then if you understand that if it's, say, they're doing a lot of institutional projects, then you might be able to share some insights based on our experience in representing clients who are doing institutional projects versus doing residential projects. And so each project is different and they have different issues. So once you understand the issues that the potential client has, what kind of projects they're involved in, you can then provide hopefully some insights as to the issues associated with those kinds of projects.
I think you want to first have an understanding of what type of operation they have, what size of a company it is, whether they rely upon any standard forms of agreements for their contracting principles, and maybe engage them in some discussion about whether they've had any incidents recently that might have involved a property damage or personal injury or a contracting dispute. And this way bring them into the whole discussion about what it is that we can offer. And we have a fantastic team of attorneys up here in New York, Philly, and Maryland who can handle construction-related issues for design professionals.
Yeah, I think that you want to ask whether what they use as a contract. You know, we have a lot of clients that just use letter agreements, that just use scope of work proposals. It's good to sort of feel out or suss out whether they have an actual, what's called an AIA contract, or some other legal document. You know, proposals are great, letter agreements are certainly binding, but they're not the best, and they don't usually include things for dispute resolution, for example, provisions for what happens when the relationship sours, stuff like that. So it's good to sort of feel out, what do they use? What's the mechanism, the written mechanism by which they have projects or have counterparts? And I would say to anyone who is in that encounter or who's speaking to prospective clients to really pitch the fact that we have folks with really deep expertise in very technical areas of construction law, things that are pretty boring to everyday folks like indemnification, but that are just, in insurance especially, I mean, things that are just so important to the success of a project and for the peace of mind after a project ends, to know that you're not going to get into trouble. And so I would really pitch those technical areas of expertise.
The things I deal with are mainly property damage, personal injury, defective workmanship, contractual disputes, including delay-type damages, things gone wrong in construction projects is what it amounts to. And those are the typical categories. Either the thing was built wrong, is defective, or somebody gets hurt or property gets damaged in the course of it being done, or you have commercial type disputes between the parties, payment disputes, delays and stuff like that.
Today, I want to talk about a couple of topics that I deal with on a regular basis in contract negotiation for our design clients. The topics are termination and dispute resolution, and these are two topics that are hard to talk about when talking about contracts negotiations at the beginning, because you're talking about what happens when something goes wrong. And so it's a difficult discussion for our clients to have. Yet it's an important discussion because they're very important topics, and at the same time you learn something about your client, how they respond and negotiate those issues. And so we really insist that our clients take these issues on early, even though everything might be wonderful, they're having a love fest with their clients, yet they need to think about, well, what happens if something goes wrong? And what's happened recently in the last number of years, the AIA, Institute of Architects, has permitted owners to terminate contracts for convenience. And that's introduced all sorts of issues associated with use of plans when there is a termination. How can they be used? Who owns the plans? Should they be paying a fee for those plans? There are issues associated, obviously, with hold harmless and indemnification. In other words, if the owners are going to use the plans and have that right under the contract, are they going to hold the architect harmless from those claims that might arise? Does it depend on whether the plans are complete for construction at the time of termination, or are they halfway through design? So these are all the issues that come up in a negotiation in terms of trying to define what rights an owner has when the project, if she does terminate. So it's really important to address these issues, to understand the indemnification possibilities, understand whether there should be a licensing fee for use of the plans if the owner is going to have the right to continue. And so this is a topic that has to be addressed. As for dispute resolution, it used to be, up until a number of years ago, pretty standard for every dispute to be arbitrated. Now the AIA has what they call a check-the-box method for determining dispute resolution, and you can check arbitration, you can check litigation. There's also another box called other, if there's some other way you have in mind for dispute resolution. Mediation is a required predicate to either arbitration or litigation. And again, this is a topic that comes up. Many commercial owners, in our experience, and some high-end residential owners do not want arbitration. They think it's just not fair. They think it's biased to the architects. So we generally recommend arbitration because it's private, it's generally less expensive. And in New York, at least, we can't speak to other states where the firm has offices. It's the jury trials, the courts are very backlogged, and I don't think anybody wants to be in front of a jury for weeks on end in a construction dispute, which often happens in New York. And so we encourage arbitration, but sometimes we have to give in on that issue. Insurance companies often have different opinions. Some of them favor arbitration, some favor litigation. And so in deciding what dispute mechanism to put into an agreement, we generally want to get the input from the insurance company that would be providing insurance coverage for our clients, talk to our clients' experience about arbitration or litigation in prior matters to see how they feel about it, and then come to some resolution. But again, it's a topic that has to be discussed early on in contract negotiations, and you do learn a lot about your client through how that discussion goes. So those are just two topics that come up a lot and need to be addressed.
I'm doing a presentation today just as a way to introduce you to some of the project delivery methods that are used on real estate development or construction projects. And I'm going to be looking at it from the architect and engineer's perspective when you find yourself in the project. If you're looking at the slides that I've prepared briefly for this presentation, I like to use this diagram that I've sourced from the American Institute for Architects that shows the contractual relationships amongst the parties. And it shows a traditional, which is a design, bid, build project delivery method, which is when the owner retains an architect for a project, which you see on the left-hand side of the diagram. And then the architect brings in consultants. And once design is developed and a winner of a bidding process is announced, then the owner will retain a contractor or general contractor who will bring in his own subconsultants. The advantages of that process are that the owner retains a control over the costs, but it also expands the term or the duration of a project, because only after a design is completed, one will have the opportunity to bid it out, price it out, and choose usually the lowest bidder to build out the project. The alternative is a design build method of project delivery, which involves an owner retaining a joint team of design and construction, which in terms allows you to seek contractors' input early in the process and finish the project through a more collaborative process sooner. What other types of services we see on the construction projects? We see owner's representative, who is simply an advisor to the owner, who provides guidance but has no risk to the role that he or she performs on the project. We may also see a construction manager, either acting as an advisor, and therefore that CM does not retain any contractors or any trades on the project and has no risk. Or we may have a CM at risk who acts as a general contractor and retains trades, but also comes into the picture early on in the project when the project is in its design phase. So this is a hybrid way of how project delivery method may be structured. And then we obviously have a typical general contractor who holds the trades and delivers the project in a typical design bid build scenario. What types of payments do we see? We may see a cost plus fee, which is a percentage based fee with an open book. In other words, the owner developer sees what the trades costs or material costs are and has access and ability to audit and request that information from the contractor. We may also see a lump sum contract or a stipulated sum contract, where once the winner of a bid is announced, then that information that underlies the bid may be withheld from the owner. Or we may have a cost plus with a guaranteed maximum price where there's a cap and the contractor bears a risk of delivering the project at a certain price. These are the types of documents that I like to show to my participants that explain what various families of contracts are available through the American Institute of Architects suite, as well as what series of relationships exist and what forms define how these relationships are addressed through standard forms of agreement. And lastly, I was going to talk about the consultants on the project, which and what are some of the advantages and disadvantages of using a consultant by an architect or engineer on the project. And the advantages are that the architect or engineer retains control over the consultants, and those may be various visual or interior consultants. The disadvantages are that the architect has to incorporate the revenue that's generated through the usage of consultants into the premiums for the professional liability insurance carrier. What's important in creating the relationship between the architect or engineer and his or her consultants is that there's a clearly defined agreement that defines the scope of the consultant's involvement, that the insurance terms follow the prime agreement between the owner and the architect, and the ownership of drawings and project credits is similarly addressed, so that there is no issue when the project is completed, and the consultant receives whatever recognition that the owner agreed to receive in the prime agreement. And lastly, that the dispute resolution procedures are exactly the same in the top tier contract as in the lower tier contract. So I encourage you to reach out to me, ask me any questions when it comes to any disputes or any contract relationships on a new development project. We handle all kinds of matters, which may also involve some of the out-of-state or international practice areas, and we're always happy and available to answer any questions you may have, and look forward to working with everyone outside of New York and in New York. Thanks so much for tuning in.
First up, instruments of service. The point here is really to make sure you define them broadly in your contract. So you want all drawings, all specs, all specifications, all schedules, pretty much any documents that your client prepares and presents for use in a construction project, you want those to be considered instruments of service. And you want those instruments of service to remain their sole and exclusive property, regardless whether the project goes forward or not, which often happens. A project comes together and then falls apart, but you want to make sure the ownership sticks with your client. You also want to make sure that they retain all their common law, statutory, and other rights in those instruments of service, including everyone's favorite reserved right, which is copyright. If you're representing someone who is receiving instruments of service from someone else, then you want that someone else to represent that either they themselves are the copyright owner or that they have permission from the copyright owner to transmit those instruments of service to you for use on your project, because what you want to avoid is having sort of third-party unknown folks out there who should have a say in how the contract is worded but who you've not yet approached. And then you probably want to make sure that the other side has the right to retain copies of those instruments of service for archival purposes or referential purposes. For the future, this is often the case when you're dealing with a project that is a reno of a home or an office space. You know, they may necessarily need to look back at those documents, but you probably don't want them to use those instruments of service for other projects, or you probably don't want them to fire you and hire someone else to finish the job for you. And so those are all things that deal with licensing, which I'm not going to get into, and you're going to want to make sure that you have the right licensing fee, the right indemnification provisions, all of that. As for photography and credit, you are going to want to negotiate up front your designer's right to include photographic and artistic representations of the design that they've created for the project amongst their promotional materials and professional materials. Depending on who your counterparty is, that right might be subject to prior written approval. It might be subject to confidentiality or proprietary concerns. So for example, you may need to avoid disclosing the project address or the name of the owner or any other proprietary information that the person you're working with might have. And you're also going to want to make sure that you negotiate for your client the right for reasonable access to the site after the completed project. Often you run into situations where the project's over, everybody's kicked out, and it's a private property, so you don't have the opportunity to go back in there and really photograph the space in the way that you want. If the owner or another party involved in the project is going to represent your work photographically, then you want to negotiate a right, some say in that for your client. You want them to give appropriate professional credit to your design client, and you will probably want to agree up front how that credit is going to look, how it's going to be worded. That's particularly true if you have a project involving multiple architects or multiple designers. Who is the architect? You know, if your client is the initial architect, someone else is brought on in a collaborative, mutually benefiting situation halfway through a project. At the end, who's credited as the architect? Are you both? And so those are things that everyone is going to want to have a say in. And then lastly, installations. This isn't such a popular thing, but if you have clients that are doing public art installations, or that or you're hoping to onboard clients who work in that area, there are things that you'll want to discuss with them in advance. Things like, how do you coordinate for maintenance of a piece. If you have an artist client who is installing something perhaps in the city somewhere, who's going to maintain that? Are they going to have the right to periodically document the condition of the work? Will there be a catalog or some other publication afterwards? How is it going to be removed? Is it going to be destroyed? Does it go back to your client? Is your client responsible for restoring that project site back to its original condition if it is in the public sector? So those are all things that you'll want to watch out for, hopefully issue spot for, to attract your clients.
The types of litigations that we typically handle usually involve multiple parties, because whether you're talking about an excavation damaging a building next door, or a worker being injured on the project, or one of the subcontractors complaining that the other subcontractors are delaying or impeding their work, or the project owner complains of multiple different kinds of defects in the building after it's completed. In any of these situations, you have as many as a dozen or more defendants all pointing the fingers at each other. So the case usually becomes about which of all these parties is liable to the plaintiff for whatever it is that went wrong, but also which parties can transfer their liability onto the shoulders and get reimbursement from which other parties. And there are various legal theories that parties use to transfer liability in that fashion, and we commonly deal with those theories all the time. 4 of them in particular. One is common law indemnification, which is a theory that enables you to get reimbursement if you're being held liable for the wrongdoing of somebody else, vicariously liable, such as by respondeat superior or because of a strict liability statute. Another theory is contractual indemnity, where the parties agree in advance that if one party gets held liable for something that they weren't really at fault for, that one of the other parties will pay for that. Another one is contribution, which usually applies where you have multiple defendants being held jointly and severally liable, and the plaintiff enforces its judgment against one of the defendants for more than its fair share of the liability. That defendant can get reimbursed by the other co-defendants. Another theory that you see is claims of failure to procure insurance that a party agreed in its contract that it was going to procure for the benefit of other parties on the project. And each of these different theories has its own rules, its own features. Each may apply only in one situation and not another situation, or may be available between certain parties but not certain other parties. For example, the other parties on a project typically can't get common law indemnification from the party that employed a worker who got injured, because workers' compensation law prohibits that. So you need to understand all these theories in order to avoid potentially making a serious strategic mistake. For example, you could settle by paying money to the plaintiff to get out of the case, only to have your co-defendants turn around and get judgments for indemnification against you for the liability that they were held to have to pay to the plaintiff. Or you might get a claim dismissed against your client that would have been covered by your client's insurance coverage, only to then have liability imposed on your client for the same damage based on some other theory for which their insurance coverage does not apply. So in addition to protecting our A&E clients against all these kinds of unfortunate outcomes in litigation, we also advise them how to conduct their business and protect themselves contractually against this kind of problem.
I'm going to talk a little bit about building delivery methods, but I'm not going to repeat Wojtek's presentation because he did such an able job. What I'm going to try to give you is a little bit of what to listen for and questions to ask of your mid-market corporate clients who may be undertaking a capital project. In the first instance, I think what you need to be listening for is, is the owner contemplating undertaking a commercial, a project, a construction project? And at that point, some of the things that you need to be asking are, what industry is my client actually focusing in? By way of example, I know we have quite a few hospitality clients who build hotels. We have individual attorneys who represent auto dealerships who obviously construct showroom facilities and shop facilities. We have cannabis clients who primarily are doing construction in the grow facility or the retail segment space, and other financial institutions that are likely doing construction of data centers, branches, and other types of financial institutions. So the purpose of what you're listening for is because ultimately you need to be listening to what type of a facility they are planning in order to gauge what construction delivery method may be appropriate for them. You heard Wojtek talk about the traditional method, which is design, bid, build. He also mentioned design, build, and the construction manager at risk or integrated project delivery method. When it comes down to your particular client who's looking at doing a capital improvement project, the type of facility that they're constructing should be a consideration with what type of delivery method they're contemplating. By way of example, if you have a hospitality client or you have a cannabis client who's looking at building a grow facility, the delivery method that we would likely talk to them about would be a different delivery method than if they were looking at building a facility for a retail space. Is it a renovation or is it new construction? Another important question to ask, because if it's a renovation, you're probably going to want to contemplate more of a traditional design, bid, build, where the owner would have a direct relationship with an architect and then separately engage a contractor. If you have a client who's looking at a warehouse facility, however, you may likely want to contemplate design build because of the speed of the process in which that delivery method is able to get to substantial completion on the building, and ultimately the price differential with respect to having that single point of contact where the owner contracts only with the design build entity. The design build entity then contracts with the architect and engineers. Other considerations that you will want to contemplate and ask your client about is there public financing being provided? If there's public financing, or if it's a public project, there are different statutory requirements for, by way of example, prevailing wage. Also, the type of delivery method. If you're in Pennsylvania and you have a public project, we have a delivery method that requires a Separations Act that requires multiple prime delivery. And that brings a lot of challenges to delivering the construction process or the construction project. So those are the types of questions that you can ask and ultimately inquire and have a somewhat intelligent discussion with your client, and then ultimately look to refer that client to one of our attorneys in the construction practice group. Again, the primary delivery methods that you're looking at with respect to our region, and again, region is another area that you need to contemplate and have a question. Ask them where they're looking at constructing this warehouse or this grow facility or this hotel, because the region will also dictate or at least counsel the delivery method that you may want to contemplate and have a discussion with your owner. With clients, I always tell them the sooner that we are involved, the better, ultimately for the success of the project. It's better from our perspective to be involved in the contracting and have tight contract documents up front rather than at the end of the project only being involved in the claims process. It's more beneficial for the client. it makes a more streamlined project, and it generally results in more success for the client. So that is a general item that I counsel all clients with. It's better to have someone familiar with construction contracting up front rather than just bringing us in to handle the claims process. In addition, during the construction process, there's quite a bit of discussion, negotiation that are tied to the contract documents. By way of example, they're ordinarily requests for information or RFIs. There are change order requests. There are process change orders. There are applications for payment. There are certificates of substantial completion. There are punch list items. There are warranty items. All of these process and procedures during the construction project can become contentious, and ultimately having someone familiar with the contract documents and the process can not only assist making the project smooth, but also reducing the potential for claims at the end of the project and the size of those claims. Ultimately, however, if you get into a circumstance where there are claims, where there's a demand for mediation or a demand for arbitration or litigation is filed, our construction practice group also offers those services. It's actually a significant portion of what I do on a daily basis. Again, what I'd like to stress to clients and what I think others outside our practice group can stress to their clients is it's better to, an ounce of prevention is worth a pound of cure. It's much better to have tight contract documents, tight construction contract administration up front rather than be facing a multi-million-dollar claim at the end of a project. There are no guarantees in the construction process, but certainly having tight contract documents minimizes the risk to the client. If you have any questions, you can reach out to me. I am in the Harrisburg office, and feel free to please give me a call.